You saw your driver's license in your purse at that time? Yes. After you got gas, did you proceed to the defendant's house? Yes. And do you know what her address is? It is on Greenfield? Yes, but I don't remember the exact address. Do you recall about what time on the 21st of January you arrived at the defendant's house? I think it was between 10 and 11. It was late in the morning. Question by plaintiff's attorney. We're still in direct examination. 180. Ready? Did the defendant suggest that you do anything? Well, she asked if I would drive her over to Hughes Market. She had to either cash a check or money order. I forgot which. Did you drive her to Hughes Market? Yes. Was that on National Boulevard? Yes. Did she go into Hughes Market? Yes. Did you wait a while? Yes. Then she came out? Yes. Then did you return to her house? Yes. When you went to the defendant's house, did you have an infant child with you? Yes, I did. And is there anything in particular that you recall that you had done with the checks that were in your checkbook that you took with you, that I had done with the checks? Had you numbered them? Yes. Counsel is leading the witness. Withdraw the question. What had you done with the checks? I had just put a new checkbook in. I wrote 2 checks and I had numbered them. What was the numerical sequence? Well, I usually number them to about 100 and 200, and I would start over again. When you returned to the defendant's home, would you describe what happened next? Well, it was getting late, and I asked her if I could feed the baby before I left to go home, and she said yes. And I went in the kitchen and fed the baby. Do you know where your purse was at that time? It was in the living room on the couch. You left it there? Yes. What did the defendant do when you went into the living room, into the kitchen to feed the baby? She gave me the pan and put it on the stove, and I took over from there, and she left the room. Was either Mr. or Mrs. White with you at any time while you were preparing the food for the baby? After she gave me the pan, she left. Could you hear any conversation going on between them? The kids were making quite a bit of noise, but I didn't hear him or her. Did you again see the defendant while you were preparing the food for the baby? Not until the end. What happened then? Well, then she came in the kitchen when I was taking the baby out of the high chair. Did she say anything to you at that time? Not that I remember. Did she? Oh yes, pardon me. She said she put my purse in the bedroom so that the children wouldn't get in it. Then did she remain in the kitchen with you? Well, we went into the living room then, and we had another cup of coffee, and I left. Now, when you left, how did you get your purse, if you did? She went in the bedroom and got it for me. She brought the purse to you, is that right? That's right. Then did you go somewhere before you went home? Well, I picked up my little boy from school and came home. That is the only stop you made? Yes. Did you open your purse at all during the time that you were en route from the defendant's home to your home? No. After you got home, what did you do? Well, I was going to get ready for work, and I happened to notice my checkbook was missing, and I got on the telephone. How long after you were home approximately? Maybe about 20 minutes. All right. About what time would this be if you can estimate it? By the time I got home, it was about 2:30 more or less. About 2:30, you noticed your checkbook was missing. Is that right? Yes. And what did you do when you found that it was missing? Well, I dropped everything out of my purse and I called her right away. Whom do you mean? Mrs. White, sorry. The defendant? Yes. And did the defendant answer the phone when you called her? Yes. What did you say to her and what did she say to you? I told her my checkbook was missing and I said that I must have dropped it in her house. Would she please look? And she looked and she said she couldn't find it. She told you she looked. Is that right? Well, she went and looked. I hung on the phone. She looked. You don't know what she was doing? No, I don't know what she was doing. She said she looked. She came back and said she couldn't find it? Yes. While you were waiting for her, did you talk to anybody else? She went outside to look between the house and the car. I parked in front of the house, and while she went there to talk to her husband. What did her husband say? Objection, it would be hearsay. Sustained. It isn't offered to prove the truth of the matter asserted. No. Your next question. Did the defendant come back to the phone? Yes. Did she say anything further to you? She said she couldn't find it, and she told me that no one could cash my check without identification. At this time, were you aware that your driver's license was missing? Let me see. It has been so long. No. Now, did you immediately report the loss of your checkbook to the bank? No, I waited until Monday. Now, when you went and reported it to the bank, did anyone at the bank ask you for any photographs? Objection, that would be hearsay. You may answer the question yes or no. Yes, they asked me if I had any photographs. This wasn't a police officer, was it? No. Did you eventually provide that bank personnel with photographs? Yes.
Cindy, when you say en route, how do you spell that?
E-N space R-O-U. Okay, first one, 180. 180 RPR lit. Ready? Mr. President, I congratulate the senator from Ohio, who is the ranking minority member of the subcommittee, the senator from Minnesota, and the senator from Wisconsin for the work they did on the bill when it was considered in subcommittee and in committee. It is a very complex problem, and the further one gets into the bill, the more complicated it becomes. We had some open hearings on the bill. A number of changes were made to it. I believe there was some study and some consideration of the important points involved. But I am not a bit certain that under the pressure of work within this committee operates, sufficient attention was given to the mechanics of this bill in order to avoid the pitfalls that the previous bill contained, or in order to avoid what I think is the fundamental pitfall, namely promising more than we can produce. Over and over again in the past few years, Congress has, through legislation with high ideals, promised to the American public great new programs which will solve all the social evils of the country. And this is one more of that kind of idealistic approach. I have nothing against ideals. I am for them myself, but I wish Congress would not go on spending the money of taxpayers thinking it will be a cure for all our country's social ills and then not be able to solve most of the ills to which the legislation addresses itself. I made some individual comments on the bill in the report, some of which I think are worthwhile repeating here. I voted to report the bill so that we could get it out on the floor and consider more fully many of the problems which I feel were not sufficiently dealt with in committee. I hope in the process of consideration of this bill in the limited time we have, that we can correct some of the defects in it. What have we done in this bill? We have authorized $2.9 billion over a 3-year period. And the first year's authorization will be devoted to planning and mechanics, and then the major portion of the authorized amount will be spent in the following 2 years. I argued at this point before the committee. I got nowhere with it there. But I bring it up again because I believe that if this bill gets through and does not get vetoed, and I think that is somewhat unlikely if it is still in its present form, and then when we get into the actual operation and get into the number of applicants called for under 25,000, we will be in serious administrative trouble. A diagram of this report that I drew appears on page 10 of the report. Reference to that diagram clearly shows that we have so many overlapping local councils, state councils, program committees, that the prime sponsor in fact does nothing. There is no requirement that any councils or committees must reach a decision. Nevertheless, that decision has to be reached and made before any program can go forward so that any one of the councils could sit on its hands as long as it wants to. No matter how many other people want a program to start, it could not even operate. I would say that that is another very pressing problem. It is interesting to me that on the calendar, the bill is listed as the Head Start bill. Now, the bill itself is said to strengthen and expand the Head Start program. And the fact is, there is about as little relationship between this program and Head Start as it is now operating as there is between a monkey and an elephant. There is no relationship. I have seen many children that have been well cared for, who have been well educated, and who have come to the determination that they did not want to do anything, and they have not. They have either dropped out or have not realized their full potential. They have been taken to psychiatrists and psychologists, and they have not proven very much to themselves or to anyone else. However, they have had the benefit of all the services that are supposed to be the very best from the very beginning. I would say once again, and try to emphasize as I have ever since I have been in Congress, that there are differences between people, and we cannot get some kind of predetermined standard set up by an expert in Washington and determine that this is the mechanism by which a child will reach his potential. It takes far more than that. And then we go on to the question of bureaucracy, and this is a honey, and I am not sure I can explain it. I am not sure I can stand here, having been all the way through the hearings and having read the bill and having looked at the wording of the language and tried to explain it to the Senate. I certainly cannot, at least not without the chart on page 10, showing what the various areas of responsibility of the committees and councils are. In any event, we have to set up a Child and Family Services Council. And usually when we set up committees and councils, we set them up in an advisory capacity. However, we do not do that here. This is what we do with the Child and Family Service Council in this case. They will be entitled to approve annual programs, basic goals, policies, and procedures, the selection of any agency, and will be responsible for the annual child development and family service programs contained in their area. This is what the Child and Family Service Council does. It is an operating group. 200 RPR jury charge. Thank you very much, ladies and gentlemen, for your patience during the presentation of the evidence and the argument of counsel. The court charges you that the mere fact that there has been an accident and as a result thereof the plaintiffs have been injured does not in and of itself entitle the plaintiffs to recover. In order to recover in this case, the burden is upon the plaintiffs to prove by a preponderance of the evidence that the defendant was negligent and that such negligence was the sole proximate cause of the accident. Negligence is the failure to exercise reasonable care or the violation of some positive duty imposed by law. Reasonable care is that care which a reasonably prudent person would have exercised under the same or similar circumstances. A proximate cause of an event is a cause which in the natural and continuous sequence unbroken by any intervening cause produces the event and without which the event would not have occurred. It is an act or omission which immediately causes or fails to cause the event, an act or omission occurring or concurring with another act where it had not happened, the event would not have occurred. Your verdict must be based upon sympathy for either of the parties, but it must be based upon the evidence and the charge given you by the court. The term preponderance of the evidence does not mean the greater number of witnesses, but it means that the greater weight of the evidence or that degree of proof which you find more convincing and worthy of belief. The testimony of one witness in whom the jury has confidence may constitute a preponderance of the evidence. In determining the preponderance of the evidence and the weight which you see fit to give to the testimony of the witnesses who have appeared before you, you may take into consideration the demeanor of the witness on the witness stand, the bias of the witness, if any is shown, the interest or lack of it in the outcome of the proceedings, and the opportunity for having observed the facts to which the witness has testified, and from these and all the facts and circumstances you are to determine the credibility of the witnesses and the weight which you see fit to give to their testimony. The rules of evidence ordinarily do not permit witnesses to testify as to opinions or conclusions. An exception to this rule exists as to those whom we call experts, witnesses who, by education, experience, training, or learning, have become experts in some science, art, profession, or calling, may state their opinions as to relevant and material facts in which they profess to be experts and may also state the reasons for their opinion. You should consider each such expert opinion received in evidence in this case and give it such weight as you think it deserves. If you should decide that the opinion of an expert is not based upon sufficient education, experience, or training, or if you should conclude that the reasons given in support of the opinion are not sound, you may reject it in whole or in part. If you should believe from the evidence that the defendant was negligent and that such negligence was the proximate cause of the accident, if you should further believe from the evidence that the plaintiffs were also negligent and that their negligence proximately caused or contributed to cause the accident, then your verdict should be in favor of the defendant. The law does not undertake to apportion or balance the negligence of parties if both are at fault in order to ascertain which one is most at fault. Instead, the plaintiffs are barred from recovery if they committed any act or negligence which proximately caused or contributed to cause the accident. Now, where a defendant relies upon a contributory negligence of the plaintiffs as a defense, such contributory negligence is not presumed, but the burden is upon the defendant to prove by a preponderance of the evidence that the plaintiffs were guilty of such negligence and that any such negligence proximately contributed to cause the accident. Unless the defendant proves the existence of such negligence, or unless such negligence appears from the plaintiff's own testimony, or can be fairly inferred from all of the circumstances of the case, then you cannot find that the plaintiffs were guilty of contributory negligence. If from the evidence and the charge to the court you find your verdicts in favor of the plaintiffs, you will then assess the damages to which you believe they are entitled. Damages are not presumed, nor may they be based upon speculation, but they must be proven, and the burden is upon the plaintiffs to prove by a preponderance of the evidence any item or element of damage claimed and that it is properly attributable to the accident. Unless such element or item of damage is thus proven by preponderance of the evidence, the plaintiffs cannot recover therefore, but the burden on the plaintiffs to prove their damages by a preponderance of the evidence does not require that they prove with mathematical decision the exact sum of their damages, but only that they furnish evidence of sufficient facts and circumstances to permit an intelligent and probable estimate thereof. When you retire to your jury room, elect one of your number as foreman. It will be the duty of the foreman to preside over the proceedings to see that each member of the jury has full opportunity to discuss the case, the evidence, and to express such juror's opinion. Now, the foreman has an equal right with other members of the jury to vote. Any findings by you must be the unanimous finding of the jury. During your deliberations, if it becomes necessary to communicate with the court, the foreman will do so in writing. Paper and envelopes are provided in the jury room. The foreman will write a memorandum. (225) two voice. RPR. Ready? Would you please state your name, Edith Sanders? What is your address? 350 South Clark Street, Chicago, Illinois. How long have you lived at that address? About 14 years. I can't remember the exact date. Are you employed? Yes. At the time of the accident, I was working for Homemakers. And what type of job is that? They send you out on jobs to do housework, babysitting, or whatever they have available. How long have you worked for Homemakers? I think it was just about a year. You are the plaintiff in a suit against Mr. Samuels, are you not? Yes, I am. Now, this is as a result of an accident which occurred on December 23, 1973. Is that correct? Yes, that is correct. Would you describe in your own words how the accident occurred? I was at a complete stop getting ready to turn into the shopping center when I was hit from behind. Where had you been just prior to the accident? I was at home. At the time the accident occurred, you were about to negotiate a left-hand turn into the shopping center? Yes, I was. Were you aware that there was going to be an accident prior to the impact? I sure wasn't. About what time did this accident happen? I think it was approximately noon. The weather conditions were good? Yes, it may have been a little bit cold, but it was a sunny day. Would you describe what happened as far as your body is concerned and anything you hit inside the car? Well, I hit the headrest. Did any part of your body strike anything else? No, just the back of my neck. So you did not hit the windshield, the dashboard, or the side window? No, I did not. Was your vehicle stopped at the time of the impact? You mean, was it at a complete stop at the time? Yes, I think it was. How many lanes of traffic are there on Broadway? I don't remember exactly, but I think there are 4. After the accident occurred, what happened then? The people that hit me came up to see if I was hurt. You say people. Was there more than one person in the other car? He had a girlfriend or a friend or whatever it was. And then what happened? Was there any conversation? Yes, they asked if I was okay. What was your response, if anything? I don't remember what I said now. I was in a state of shock. But you remember them coming up? Yes. And then what happened? The police came, but I don't know who called them. Did you talk to the police officer when he arrived? Yes, just routine questions. Have you received any medical treatment as a result of the accident? Yes, I sure have. When did you first seek medical treatment? I went to my family doctor the same day, which would be December 23? Yes, the same day. What happened then so far as medical treatment is concerned? He sent me to a hospital for x-rays and then he sent me to Dr. Scott. And when did you first see Dr. Scott? I would say about 2 weeks later. What did he recommend? Pardon me. At the time I saw my family doctor, he advised me to start wearing a neck brace. Your family doctor, Dr. Ellis, is the one who prescribed the neck brace? Yes. This was prior to the time I saw Dr. Scott. Did you purchase a neck brace? Yes. Were you wearing the neck brace when you first saw Dr. Scott? Yes, I'm sure I was. What type of treatment did Dr. Scott suggest? Now, the first type of treatment I had was hot packs. Was this at home? No, at the hospital. Then I had some kind of electric treatment. I had about every kind of treatment they have out there. But once you started the treatment, did you ever go back to see Dr. Ellis again? No, he is through with me. Did you see Dr. Ellis just the one time? No, I saw him 2 or 3 times. Have you seen any other doctors besides Dr. Ellis and Dr. Scott for injuries you received in this accident? Yes, from Dr. Scott I went to Dr. Roberts. When did you first see Dr. Roberts? I can't remember the date. How many occasions did you see Dr. Roberts? I must have gone there 5 or 6 times. What did Dr. Roberts do for you, if anything? I developed an infection in my neck and he treated it. Do you know how the infection occurred? No, I don't know how that happened. Now, going back to the accident itself, what injuries did you receive to your knowledge as a result of the accident? A neck injury, it goes down to my arms and down to my back. What goes down to your back? The hurting in my neck, the back of my neck. You mean it starts in your neck and goes to your shoulders and then to your arms and back? Yes. Is this a constant thing or what exactly is involved? Sometimes it lets up, but then at times I have it for days and days constantly. Do you have any tingling sensation in your fingers? Yes, I have had that. Which hand? Both of them. Now, referring to the incident 2 or 3 weeks ago that led to the surgery by Dr. Long, what were your complaints? The back of my neck hurt so bad that I felt like crying. You are talking about the back of your neck right there in the back. Did your shoulders also bother you at that time? They sure did. Did you have headaches? I sure did. And what about your arms and your hands? They hurt something terrible. Did he indicate to you what the problem was or what was causing this? No, he would not say. He just wanted me to check into the hospital. I noticed today you have some bandages on your neck. Yes, they are from the surgery last Friday. Do you know what they did? No, doctors used big words that you can't understand them. I don't think they want you to understand. Have you had any other hospitalizations as a result of this accident? Dr. Rogers wanted me to, but I couldn't afford it. Have you ever had any prior injuries to your neck? No, I have always been healthy. Have any of your doctors indicated to you that you received a permanent injury as a result of this accident? No. I have tried to get it out of them. But you could transcribe it. Okay. Okay, 180 RPR lit. Mr. President, every session of Congress always ends with much work left undone and many jobs unfinished. That is in the nature of things and is not likely to change. But there are some tasks that cannot be delayed and there are some times that cry for change. One of those tasks is the reform of the election process to correct the abuses rooted in money and secrecy. Congress must not go home without taking notice of the public outcry against failures of government and without changing the patterns of the past. No problem facing our nation today is greater than that of the steady increase of confidence in our political system and in ourselves. Now, this results from much evidence that our present campaign system corrupts our principles, our leaders, and ourselves. Reform of that system is essential so that we can restore confidence and self-respect, and this is necessary so that we can take care of the other problems we face. We all take the oath to support and defend the Constitution. Our procedures have been under attack for the past few years. The spirit and intent of the law has been abused, and in some instances, the letter of the law has been violated. This is particularly so in our campaign and election systems. Members of Congress must feel the weight of their responsibility for reform that bears not only upon the national legislature, but upon each member individually as elected representatives and as practicing politicians. If the Congress cannot now provide an answer to election reform, there are nonetheless many personal solutions that can be taken. In 1973, the Senate passed a Campaign Reform Act that bill had many provisions which were supposed to be an improvement in federal election campaigns. Yet that bill now lies in a House subcommittee. It is dead for the 1974 campaigns. Its promises are empty. In 1973, the Senate talked about public financing of campaigns. A majority of senators agreed that this step was necessary and proper to make our system one in which we can all once again take pride. Yet public financing was taught to death on this floor. And while we have the firm promise of committee action within the Senate on public financing bills next year, we know such action cannot affect 1974 campaigns. In 1974, we can accomplish much. In 1974, the Congress can enact public financing. In 1974, Congress can enact legislation to set ceilings on contributions and campaign spending. In 1974, the President can join with the Congress and the courts in seeking to ensure that the abuses of the past are accounted for and that our campaign system is such that these things cannot recur. We must do all of this even if we realize that the laws now in effect will still be in effect in 1974. And so we contemplate what more we are able to do now. Laws as a general proposition measure the outer areas of human behavior that are prohibited by society. Laws leave us freedom to choose the level of social attitudes that we will exhibit toward our fellow men. And thus, the law prohibits crime but leaves us free to determine whether we will in fact live in love and charity with our neighbors. Thus, the law exacts through taxes a minimum contribution for public welfare and defense, but leaves us free to volunteer personal work and gifts for the causes we think are also important to our community. Why should we not consider that election laws be seen in the same light? Now, these are not the rules I have lived by in the past. They are different from the rules followed in 1960 when I was first elected to the Congress. They are different from 1968 when I was first elected to the Senate. Indeed, they are different from last May when many members of the Senate honored me by their presence in Baltimore at a fundraising dinner from which a balance remains. Perhaps we all should have been wiser in years past, but we cannot turn back the clock and start reform in 1960 or 1968, or even 7 months ago. What we can do is start now. In seeking this new start and this new direction, it is necessary to make a goal clear. And that goal is not some high degree of personal virtue. After all, it is our ancient prayer that the Lord should not weight our merits, but pardon our offenses. What I am seeking is rather a new system, a new method, a new standard which will make our government more truly democratic. None of the steps I have listed are presently required by the federal law. Some of them go far beyond any proposals which we have debated and supported. But in each case, those who have recommended such steps have been told that no candidate could run a good campaign if he abided by such rules. In each case, I have argued to the contrary, and so today I pledge to test out my own beliefs. I am confident that the people of Maryland can demonstrate to the Congress that campaign reform can work. It is the road I feel I should take. $200 RPR jury charge. Ready?